night of August 20th, 1989, Jose and Kitty Menendez were sitting in the den of their Beverly Hills mansion watching television. Jose was eating ice cream. Kitty had strawberries and cream. They were watching the 1987 James Bond film, The Living Daylights. Their two sons, Lyle and Erik, came into that room with shotguns and killed them. This is not in dispute. It has never been in dispute. Lyle and Erik Menendez admitted to the killings before their first trial began. They have admitted to the killings in every legal proceeding since. They admitted to it on the confession tape that Dr. Jerome Oziel recorded during a therapy session in December 1989. Lyle said so in his statement to the court in May 2025, standing at a resentencing hearing 36 years after the night in question. On August 20th, 1989, I killed my mom and dad. The question that has defined this case for more than 3 decades, the question that hung the first jury, that the second jury was not allowed to fully consider, and that the California legal system is still wrestling with in 2025, is not whether they did it, it is why. And whether that why, if true and if properly presented to the jury that convicted them, would have produced a different verdict. This video is about the specific evidence that was not shown to the jury that convicted Erik and Lyle Menendez of first-degree murder in 1996. Not rumors, not speculation. Documented evidence that existed, that was known, that was either excluded by a judge's ruling or was not yet available at the time of the second trial. Evidence that the District Attorney of Los Angeles County, in October 2024, said his office believed would likely have changed the outcome. Before we get into the specifics, drop your location in the comments right now. Where are you watching from? The Menendez case has never really left the public consciousness since those early court TV broadcasts in 1993. But it came back to the center of national conversation in 2024 with full force. 2 Netflix productions, a Peacock documentary, social media campaigns with millions of followers, celebrity advocates including Kim Kardashian, and ultimately the resentencing hearing in May 2025 that reduced the brothers' sentences from life without parole to 50 years to life, making them immediately eligible for parole. In August 2025, the California Parole Board denied both brothers parole, citing ongoing violations, including cell phone infractions. Both will be eligible for a second hearing in 2028. Subscribe to Cold Case right now. Hit that subscribe button, activate the notification bell, and smash the like. This is a case where the gap between what evidence existed and what evidence the jury actually heard is the story. And understanding that gap, precisely, specifically with dates and names and what was said and what was blocked, is what this video is about. Now let me give you the full context you need before we get into the specific evidence. Jose Menendez was a powerful figure in the American entertainment industry. Born in Cuba, he immigrated to the United States as a teenager and built a career in business that took him to the top of the entertainment industry. By 1989, he was a senior executive at RCA Records, a subsidiary of the RCA company that had been acquired by Bertelsmann Music Group. He oversaw artists. He managed contracts. He was, by every public measure, a successful man living the American dream in a Mediterranean-style mansion in Beverly Hills with his wife and 2 sons. His sons described a different private reality. In their testimony during the first trial in 1993 and in subsequent legal filings, Erik and Lyle described a home where their father exercised absolute control through a combination of extraordinary pressure to perform academically and athletically, emotional manipulation, physical punishment, and, they alleged, sexual abuse that began when they were young children. The prosecution's counter-narrative was straightforward. Jose Menendez was demanding but not abusive in any criminal sense. His sons were spoiled, entitled young men who killed their parents in order to inherit a $14 million estate. The motive was greed. The abuse claims were fabricated after the fact to avoid accountability for what was, in the prosecution's framing, premeditated murder for financial gain. That was the argument in 1993. It was the argument in 1995 and 1996. And it was the argument that the second jury heard, in a trial where the judge had specifically ruled that substantial portions of the abuse evidence could not be presented. Let's start with the first trial, because understanding what the first jury heard, and what happened to that jury, is essential for understanding why the evidence exclusions in the second trial mattered so much. The first trial began in July 1993. In an unusual arrangement, the judge ordered simultaneous trials before 2 separate juries, One jury for Erik, one for Lyle. This was done to account for potential differences in the evidence against each brother. The trial was televised, mostly on court TV, and it became one of the first criminal trials to generate the kind of national media saturation that we now associate with high-profile cases. It ran for approximately 6 months. During that trial, the defense presented extensive testimony about the abuse. Family members took the stand. Expert witnesses testified about the psychological impact of sustained childhood sexual abuse and what it does to a child's sense of reality, their attachment to their abuser, and their capacity to recognize danger. Defense attorneys Leslie Abramson for Erik and Jill Lansing for Lyle built a case around the legal concept of imperfect self-defense, the argument that the brothers had killed their parents while genuinely, sincerely believing their lives were in immediate danger, even if that belief was not objectively reasonable. The cousin Diane Vander Molen testified in the first trial. She said that when she was a teenager staying at the Menendez home, an 8-year-old Lyle told her his father was molesting him. She said she had told Kitty Menendez what the boy disclosed. She said she never heard what, if anything, became of that conversation. Other family members described the dynamics of the Menendez household. One family member testified that when Jose was in a bedroom with one of the boys, no one was allowed to walk down the hallway outside. A cousin said Lyle told her he was too scared to sleep in his room because his father would come in at night. These were not the brothers testifying about their own experience. These were independent witnesses describing what they had observed and what children had told them. The prosecutor for the first trial called the abuse allegations the silliest, most ridiculous story ever told in a courtroom. The jury heard it anyway. The expert testimony, the family witnesses, the psychological analysis, the brothers' own detailed and emotional testimony, and then the jury deadlocked. Both juries deadlocked. Erik's jury could not reach agreement. Lyle's jury could not reach agreement. Judge Weisberg declared a mistrial. The case would be tried again. Quick question before we continue. What time is it where you are right now? Drop it in the comments. Because what happened between the first mistrial and the second trial is the core of what this video is about. The legal decisions that were made before the second trial began determined what evidence the second jury would and would not be allowed to consider. Judge Stanley Weisberg, who had presided over the first trial, remained on the case for the second. He made several decisions that fundamentally changed the evidential landscape of the second trial. The most consequential was his ruling on the abuse defense. Weisberg ruled that he was not convinced there were legal grounds in the state of California to allow expert witnesses to testify that the Menendez brothers were battered children. He blocked all expert testimony supporting the battered child syndrome defense. He severely limited the testimony of family members about the abuse. He restricted what the brothers themselves could say about it and how that testimony could be framed in legal terms. The second trial was not televised. Weisberg banned cameras from the courtroom. There were no live broadcasts. The media frenzy of 1993 was replaced by a more controlled, more contained proceeding. There was a single jury rather than two, and critically, that single jury was hearing a fundamentally different case from the one the hung juries had heard. Juror Hazel Thornton, who had sat on Erik's jury in the first trial, said in a 2024 interview, "I don't even blame the second trial jury for having reached the conclusion of murder, because they were not allowed to consider manslaughter. They were not allowed to hear the same defense that we did." Let me say that again clearly. A juror from the first trial, a juror who ultimately could not convict on first-degree murder, said directly that the second jury was not allowed to hear the same defense, and that juror believed the outcome of the second trial would likely have been different if the same evidence had been presented. Now let's talk about the specific evidence that was excluded or unavailable in the second trial, because this is where the case for reviewing the conviction rests. The first piece is the family witness testimony that was severely restricted. In the first trial, multiple family members testified about what they had observed and what the brothers had told them as children. Diane Vander Molen's testimony about an 8-year-old Lyle disclosing abuse to her and about telling Kitty and being ignored. The testimony about Jose being behind closed doors with one of the boys while no one was allowed in the hallway. These were independent third parties describing a pattern. In the second trial, Judge Weisberg limited how much of this could be heard. The jury that convicted the brothers in 1996 heard substantially less corroborating testimony from independent family witnesses than the hung jury had heard in 1993. The second piece is the expert testimony on battered child syndrome that was completely excluded. In the first trial, expert witnesses explained to the jury how sustained childhood sexual abuse affects a victim's psychology, why a victim might maintain a relationship with an abuser, why they might delay disclosure, why they might simultaneously love and fear the person who is hurting them, and why a child who has been controlled through abuse might eventually reach a point of perceiving mortal danger in circumstances that a person without that history would not perceive in the same way. This testimony was designed to help the jury understand the psychological reality that the brothers described. Weisberg blocked it entirely from the second trial. The jury that convicted them had no expert framework for evaluating the brothers' claims. The third piece is the 1988 letter from Erik to his cousin Andy Cano. This letter was written approximately 8 months before the murders. In it, Erik described the sexual abuse he had endured from his father. He wrote about it before there were any murders to justify, before there was any legal strategy to construct, before there was any inheritance to claim. He wrote about it as a boy writing to a relative, describing his experience. This letter was not introduced as evidence in either trial. The brothers' legal team did not know about it during the trial proceedings. It came to light in 2015 when it was mentioned in a Barbara Walters television special. When the brothers heard it referenced, they told their lawyers, who tracked it down. The lawyers had never known of its existence. When the habeas corpus petition was filed in May 2023 seeking a review of the brothers' convictions, the letter was one of the 2 central pieces of new evidence cited. A photocopy of it was included in the petition. Its significance is direct. It is a contemporaneous account by Erik Menendez describing abuse, written before any motive to fabricate could have existed, that was never shown to either jury that considered his case. If you're finding this breakdown valuable, if this is giving you the complete picture of what the juries were and were not allowed to hear, hit the like button right now and subscribe to Cold Case, because the habeas petition that included this letter triggered the legal chain of events that led to the May 2025 resentencing. The fourth piece of evidence, and in many ways the most significant addition to the case in recent years, is the sworn declaration from Roy Rossello. Roy Rossello was a member of Menudo, the Latin pop group that became famous in the 1980s and was the launching pad for Ricky Martin's career. Menudo was under contract with RCA Records during the period when Jose Menendez was an executive there. Rossello was approximately 14 years old when he alleges the abuse occurred. In 2023, Rossello gave a sworn declaration to the Menendez Brothers legal team stating that Jose Menendez had drugged and sexually assaulted him twice in the 1980s. He had previously discussed this publicly in the Peacock documentary series Menendez Pulsa Menudo, Boys Betrayed. His declaration was the final piece of evidence that the defense team needed to file the habeas petition. Why does this matter for the case against the conviction? Because one of the prosecution's core arguments, in both trials, but especially in the second, was that the abuse allegations against Jose Menendez were invented by his sons to explain away a premeditated murder. That Jose Menendez was not the kind of man who committed sexual abuse. That there was no corroboration, no independent evidence, nothing to support the claim. Roy Rossello's sworn declaration, if credible, does not prove what Jose did to his sons, but it provides independent corroboration of the claim that Jose Menendez was capable of sexually abusing minors in his orbit, that he had done it before, that the pattern the brothers described was not without precedent. In 2024, a judge ordered the Los Angeles District Attorney's Office to explain why this evidence, both the 1988 letter and Rossello's declaration, had been kept out of the brothers' trials. That judicial order itself is significant. It reflects a court's view that these 2 pieces of evidence were sufficiently material to the case that the prosecution needed to account for their absence. Now let me step back and address the part of this case that cannot be simplified, because it deserves to be stated directly. The Menendez brothers killed their parents with shotguns. They reloaded. They shot multiple times. The physical reality of what happened in that den on August 20th, 1989, was brutal. Kitty Menendez was shot multiple times, including after she was already wounded. The prosecution argued, and the facts support, that this was not a chaotic act of sudden panic. It was sustained. It was executed with multiple rounds from weapons the brothers had specifically purchased. The question of whether that degree of violence is consistent with a genuine, if psychologically distorted, belief that their lives were in mortal danger, or whether it was execution of a premeditated plan, is the question that both juries grappled with that the second jury resolved differently than the first, and that the legal system is still in the process of working through. The habeas petition does not claim the brothers were innocent. It claims that the jury that convicted them did not have access to the full picture of the evidence that bore on their state of mind, specifically the evidence corroborating their abuse claims, which the second jury was explicitly prevented from fully hearing. That is a legal argument. It has legal consequences, and it is the argument that led, step by documented step, from the 2023 habeas petition to the 2024 district attorney's review to the 2025 resentencing. Let's now trace that legal chain to its current status, because the story is still unfolding. In May 2023, the brothers' defense attorneys filed the habeas corpus petition. It cited the 1988 Erik letter to Andy Cano and Roy Rossello's sworn declaration as new evidence that would likely have changed the outcome of the second trial. In October 2024, then District Attorney George Gascon held a press conference and announced that his office was recommending resentencing. He said, "There is no question that a jury today would look at this case probably very differently than a jury did 35 years ago." He cited both the new evidence and the dramatically evolved understanding of how childhood sexual abuse affects victims. De Gascon was replaced by Nathan Hochman after losing the November 2024 election. Hochman initially opposed resentencing, saying the brothers had not taken complete responsibility for their crimes. But the legal process had already been set in motion, and Hochman ultimately withdrew his opposition to the resentencing itself, though he challenged specific aspects of how it was being framed. On May 14, 2025, Judge Michael Jessic resentenced both brothers to 50 years to life. The ruling made them immediately eligible for parole because they were under 26 years old at the time of the crimes. A California law that went into effect in 2018 applies retroactively to people who committed crimes before the age of 26. Judge Jessic said he was especially moved by a letter from a prison official who had never, in 25 years, supported resentencing for any incarcerated person until this case. Lyle Menendez addressed the court via video from prison. He was visibly emotional. He said on August 20th, 1989, "I killed my mom and dad. I make no excuses and also no justification. The impact of my violent actions on my family is unfathomable." The cousin Anna Maria Baralt, speaking for the broader family, told the court, "We all, on both sides of the family, believe that 35 years is enough." Not everyone agreed. Milton Anderson, Kitty Menendez's 90-year-old brother, filed a legal brief asking for the brothers to remain imprisoned for life. His attorney said, "They shot their mother Kitty, reloading to ensure her death. The evidence remains overwhelmingly clear. The jury's verdict was just, and the punishment fits the heinous crime." Both perspectives exist in the record. Both represent real people with real grief and real convictions about justice and what it requires. On August 21, 2025, Erik Menendez appeared before the California Board of Parole hearings. He was denied parole. The board cited ongoing rule violations and concerns about public safety. Lyle was denied parole the following day, with the board referencing repeated cell phone infractions. Both brothers will be eligible for a second parole hearing in 2028. They are still in prison. Now let me bring this back to the specific question this video is about: the abuse evidence that was not shown to the first jury. The phrase "first jury" in the title of this video requires a precise clarification. There was no single first jury. There were two juries in the first trial, one for each brother. Both hung. The conviction came from the second trial, where a single jury found both brothers guilty of first-degree murder. That second jury was the one from which abuse evidence was substantially withheld by Judge Weisberg's rulings. The first juries, the ones that hung, heard the family witnesses testify, heard the expert testimony on battered child syndrome, heard Lyle's tearful account of his own abuse, heard Leslie Abramson's defense built around the psychological reality of living under sustained abuse, and could not convict. The second jury, the one that did convict, heard none of the expert testimony, heard substantially less from family witnesses, did not have the 1988 letter from Erik to his cousin because no one knew it existed, did not have Roy Rossello's declaration because Rossello had not yet come forward, heard the prosecution's argument that the abuse allegations were fabricated, and was not provided the evidentiary tools to evaluate that argument against the defense's position. Juror Hazel Thornton's statement about the second trial is the clearest possible summation of what the evidence exclusions meant. They were not allowed to hear the same defense that we did. When she said that in 2024, she was not speculating about hypotheticals. She was a person who had sat through the first trial, who had been moved by what she heard, who had nonetheless been unable to agree with fellow jurors on a verdict, and who believed with the authority of direct experience that the second jury's decision would have been different with the same evidence. If you are following this case and want to keep up with every development, the 2028 parole hearing, the habeas petition's ongoing legal proceedings, and any further developments in the decades-long effort by Erik and Lyle Menendez to be released from prison, subscribe to Cold Case right now. Hit that button. Activate the notifications, because this case is still active. The legal process is still running. And what happens next matters not just for two brothers who have been in prison for more than 35 years, but for every defendant whose trial excluded evidence that bore on why they did what they did. Jose Menendez died on August 20th, 1989, along with his wife Kitty. He was 45 years old. He had built his career from an immigrant starting point to the highest levels of the American entertainment industry. He had two sons. The question of what kind of father he was in private, what happened in the bedrooms and hallways of the homes where his children grew up, has been at the center of this case for more than 3 decades, and has never been fully resolved in any court proceeding because one of those proceedings specifically prevented the jury from hearing the evidence that bore on that question. Kitty Menendez died alongside her husband. She was 47 years old. Her son said she knew about the abuse and did nothing to stop it. She told no one, if she knew. She protected no one, if she knew. And she was killed by the children she had raised and had either failed to protect or had herself failed to believe needed protection. Her brother Milton Anderson is 90 years old and has fought in court to keep the men who killed his sister in prison for the rest of their lives. That is a grief and a conviction that deserves to be acknowledged alongside the legal arguments about evidence exclusions and resentencing policy. These are not abstractions, they are people. The pain of August 20th, 1989 extends in multiple directions simultaneously. To the Menendez brothers who have spent 35 years in prison, to the Menendez family members who have rallied around them, to Kitty Menendez's family who believe justice was delivered in 1996 and is now being undermined, and to Roy Rossello, who waited decades before publicly disclosing what he says Jose Menendez did to him when he was 14 years old. All of those realities exist at once. The legal system is required to navigate them, using rules of evidence and standards of proof that were designed not to resolve every human truth but to determine what can be established beyond reasonable doubt. What this video has tried to do is explain where those rules produced a result, the 1996 conviction, that was based on an incomplete evidentiary record, and what the legal system is now doing about that. The abuse evidence that was not shown to the jury that convicted the Menendez brothers is now part of a formal legal proceeding. The 1988 letter exists. Rossello's declaration exists. Judge Weisberg's ruling that excluded the expert testimony is part of the record. The hung jury from 1993, the jury that heard what the 1996 jury did not hear and could not convict, is part of the record. Juror Hazel Thornton's statement that the outcome would have been different is part of the record. The California Parole Board will have that record in front of them in 2028. Whatever they decide, they will be deciding with more information than the 1996 jury had. That is what changed. That is what still matters. And that is what the legal process, slowly, imperfectly, after 35 years, is still working through. Subscribe to Cold Case. Leave a comment. Tell me what you think the most significant piece of excluded evidence is. The family witness testimony, the battered child syndrome expert exclusion, the 1988 letter, or Roy Rossello's declaration. And tell me what you think should happen at the 2028 parole hearing. Share this video with anyone who has followed this case and wants to understand not just what Erik and Lyle Menendez did, but what the jury that convicted them was and was not allowed to know when they decided their fate. The evidence that was withheld is now on the record. The resentencing has happened. The parole hearings are scheduled. And whatever happens next, it will happen with eyes that are more open than they were in 1996. That is what justice requires, even when it takes 35 years to get there. There is one more dimension of the evidence story that deserves to be laid out clearly because it connects the historical case to the legal proceedings that are ongoing right now. The habeas corpus petition filed in May 2023 made a specific legal argument. It argued not just that new evidence existed, but that the exclusion of abuse evidence from the second trial constituted a violation of the brothers' constitutional right to present a defense. Under the 6th and 14th Amendments of the United States Constitution, a defendant has the right to present evidence that is material to their defense. The argument was that Judge Weisberg's rulings had crossed the line from legitimate evidentiary management into unconstitutional restriction of the defense's ability to put its case before the jury. This is a different and more sweeping argument than simply saying new evidence has emerged. It is saying the original trial was constitutionally defective, that the conviction should be vacated, not just reconsidered, that what happened in the second trial was not just a closer question than the first, but a structurally flawed proceeding. That argument has not been finally resolved. The resentencing that occurred in May 2025 was one avenue of relief. It addressed what punishment was appropriate given everything that is now known, including the brothers' rehabilitation and the new evidence. But it did not vacate the underlying conviction. Erik and Lyle Menendez are still convicted murderers. They were resentenced, not exonerated. The habeas petition, which sought to vacate the conviction entirely, is a separate track. A judge ordered the district attorney to explain why the evidence was excluded. That process is ongoing. If the habeas petition were to succeed, if a court were to find that the second trial was constitutionally defective because of the evidence exclusions, the brothers would be entitled to a new trial, a third trial, one in which a jury would finally hear everything. The 1988 letter, Rossello's declaration, the expert testimony on battered child syndrome that Weisberg blocked, the full account from family witnesses. Whether that would result in an acquittal, a conviction on reduced charges, or another conviction on first-degree murder is impossible to predict, but it would be a trial where the jury had the complete picture. That is what the legal process is now working toward. That is what the evidence that was withheld from the second jury has made necessary. 35 years after the killings, 30 years after the conviction, the question of whether Erik and Lyle Menendez received a fair trial, specifically whether the jury that sent them to prison for life was given enough evidence to make that decision fairly, is still formally before the courts. The answer to that question will shape not just the fate of two brothers in California prisons, but the principle of what fairness in a criminal trial requires. Whether a judge can restrict a defendant's abuse defense to the point where the jury can no longer evaluate the central claim. Whether evidence that corroborates an abuse allegation, written months before any murder by a teenager to his cousin, is the kind of evidence that a jury has a right to consider. These are not only questions about the Menendez case, they are questions about every defendant who has ever been in a courtroom where a judge decided that a history of abuse was too complicated, too unverifiable, or too legally untested to be heard. In August 1989, two brothers decided to handle the situation in their home with shotguns. That decision is not excused by anything in this video. What this video has tried to do is explain the evidentiary record that surrounded that decision, what the jury that judged it was and was not allowed to know, and why the American legal system is still, 35 years later, trying to answer the question of whether that jury's judgment was formed fairly. The evidence is in the record. The resentencing has happened. The parole board has spoken, at least for now. The habeas petition is still moving through the courts. And the brothers are still in prison, still waiting, still alive, which is something that cannot be said of their parents. Subscribe to Cold Case, share this video, and let me know in the comments where you stand on this case. Not on whether they did it, because everyone agrees on that, but on the question this video has tried to answer. Did the jury that convicted them have everything they needed to make that decision fairly? That is the question the legal system is still asking, and it is the right question to ask. One final note, because it matters for how this case sits in American legal and cultural history. The Menendez brothers' first trial aired on Court TV in 1993. It was one of the first criminal trials to be broadcast almost entirely on live television. It predated the O.J. Simpson trial by 2 years, and in many ways it set the template for what televised criminal proceedings could do to public perception of justice. The public saw Lyle testifying. They saw the abuse allegations in real time. They formed opinions, and those opinions were overwhelmingly shaped by a media culture that did not, in 1993, have the understanding of trauma, of child sexual abuse, or of the psychology of victimization that we have developed in the decades since. The second trial was not televised. Judge Weisberg banned the cameras. The public that had watched every moment of the first trial had no live window into the second. What filtered through was largely the prosecution's framing: spoiled rich kids, motive of greed, the confession tape that mentioned no abuse, the dramatic violence of 14 shots including reloads, and a jury that had not watched the first trial, that had not heard the same defense, that was working from a much thinner evidentiary record, convicted on first-degree murder. None of this is to say the 1993 jury had it right and the 1996 jury had it wrong in any simple sense. The 1993 juries couldn't agree either. This is to say that two juries looking at fundamentally different pictures of the same case reached fundamentally different results, and that the difference between the pictures was largely determined by one judge's rulings about what evidence was too complicated to let a jury evaluate. That is what this case ultimately is about. Not the murders themselves, which are documented and undisputed, but the right of a jury, the institution that American justice trusts to evaluate human complexity, to have the full picture when making decisions about human lives. The 1996 jury did not have the full picture. The evidence that would have completed it was either blocked by judicial ruling or had not yet come to light. And 35 years later, that incomplete picture is being reassembled piece by piece in courtrooms and parole hearings and habeas petitions. Whether it eventually produces justice, whatever that means in a case this complicated, remains to be seen. Cold Case will be here to track every development. Subscribe, share, and keep asking the questions that matter.